A landmark High Court ruling has set Zimbabwean courts to reform its 47-year-old abortion law, the Termination of Pregnancy Act 1977. The court found that the act's failure to recognize mental health risks as grounds for legal termination violates women's constitutional rights. Parliament is now likely to amend the law once the ruling is confirmed by the Constitutional Court. Our reporter Talent Gore has the details.
For decades, Zimbabwe's abortion law has been criticized as too restrictive and out of touch with modern health standards and realities. Now, a groundbreaking judgment has found parts of the Termination of Pregnancy Act unconstitutional, particularly its exclusion of mental health as a lawful reason to end a pregnancy. Handing down the judgment, Justice Chirao Mugomba said the law's failure to recognize mental health as a basis for accessing safe and lawful abortion imposes a discriminatory and unconstitutional burden on women with mental health challenges. She added that excluding mental health in the definition of unlawful intercourse as prescribed in Section 106 of the Constitution denies women in such circumstances access to safe abortion services. The case was brought by the Community Working Group on Health and Member of Parliament Nyasha Batisa, who argued that the Act discriminates against mentally ill women by allowing terminations only under narrow physical health expectations.
This orientation stands in contrast to the colonial legal frameworks that historically reduced reproductive health to physical survival and treated women's emotional and psychological suffering is legally insignificant.
Stakeholders say the ruling brings Zimbabwe closer to meeting its obligations under the Constitution, the Maputo Protocol, and the African Charter, all of which promote gender equality and access to reproductive health. The ruling means that, once confirmed by the Constitutional Court, Parliament must amend the law to include mental health risk as a valid ground for abortion.
Treatment of pregnancies arising from sexual exploitation of institutionalized women under Section 106 reflects an awareness that formal equality principles are insufficient where legislative schemes fail to protect those at the furthest margins of power.
The court also urged lawmakers to expand the definition of unlawful intercourse to protect women with mental health conditions from sexual exploitation. Currently, the Act only allows abortion when the mother's life is at risk, when there is a severe fetal abnormality, or in cases of rape or incest. Critics say the restrictions have forced many women into unsafe procedures, including illegal pills and unregulated traditional methods.
I would suggest that Section 4.1 needs to be revisited in its entirety. I would suggest that we need to repeal the entire Act, and I support what Honorable Daniel Molokele has said. And instead of having a Termination of Pregnancy Act, we should have a Safe Abortion Act. In other words, a law that actually deals with the safety of women and children.
The Constitutional Court is expected to consider the ruling in coming weeks. If upheld, Zimbabwe will begin the process of rewriting the law to ensure mental health risk and vulnerable women are fully protected. Talent Gore, ZTN Prime, Harare.